Hello and welcome to Verdictum. I'm Sheetal June and you're watching today's legal news, where we update you with the latest legal developments across the country. Starting with the headlines. Supreme Court stays Ayush Ministry's notification omitting rule on misleading advertisement. Bombay High Court fines SEBI, BSE, NSE rupees 80 lakh over illegal freezing of demat accounts. Supreme Court directs states and UTs to clear judicial officers' arrears of pay and allowances in terms of SNJPC recommendations. Supreme Court to review PIL seeking integration of Braille system in public and private sector. Now, the news in detail. The Supreme Court has stayed Ayush Ministry's notification omitting Rule 170 of the Drugs and Cosmetics Rules, which is intended to tackle misleading advertisements of Ayurvedic, Siddha and Unani drugs. A division bench of Justice Hema Kohli and Justice Sandeep Mehta criticized central government's action, stating that it directly contradicted the court's previous order issued on May 7, 2024 in the matter of Indian Medical Association and Another versus Union of India and others. On August 29, 2023, the ministry issued a circular directing all states, UTs, and state licensing authorities not to take any action under Rule 170. It had issued the circular on the grounds that the necessary gazette notification would take further time, and to avoid confusion among various states, UTs, and licensing authorities, the letter was being issued to omit Rule 170. The top court in the matter of Patanjali misleading advertisement earlier in May this year had ruled that the said rule cannot be omitted and sought explanation from the ministry. Despite this, the impugned July 1st notification was issued, which has now prompted rebuke from the court. The Bombay High Court has imposed a fine of rupees 80 lakh on SEBI, BSE and NSE in two petitions for gross illegality and a draconian action in 2017 of freezing demat accounts of one doctor and his son. A division bench of Justice Gileesh Kulkarni and Justice Firdosh Puniwala held that the Securities Contracts Regulation Act mandates that Bombay Stock Exchange, BSE and National Stock Exchange, NSE protect interests of investors and does not empower such freezing on the grounds that the person was a promoter. The freezing action is also likely to shake the confidence of investors who are NRIs, said the court. The duty to safeguard the investors' sentiments and confidence is paramount, which stands breached in every possible manner in the present case, it observed. The court rejected SEBI's contention that the freezing was justified as the company had certain known compliances. After analyzing various laws, including the Depositories Act, the court said for a penalty to be imposed, the Act provides for an adjudicatory process and prescribed manner for recovery, which appears to have been completely overlooked in the freezing action. Looked from any angle, the impugned action of freezing the petitioner's demat account is grossly illegal, arbitrary and unconstitutional, said Justice Kulkarni, who authored the judgment. The Supreme Court has directed 17 states and union territories, including Haryana and Himachal Pradesh, to clear the salary, allowance, pension dues of judicial officers in terms of the recommendations of the Second National Judicial Pay Commission, SNJPC, in 4 weeks from the date of claims raised by them. A three-judge bench led by CJI Diva Chandrachud, which had ordered the chief secretaries and finance secretaries of 17 states and union territories to appear in person for failing to clear the arrears of revised salary and pension of judicial officers in terms of the SNJPC recommendations, expressed satisfaction over the compliance of its January 4th judgment and other directions by them. Closing the proceedings against them, the bench said that the chief secretaries and finance secretaries were not needed to appear in person anymore. In order to help visually impaired persons, the Supreme Court has agreed to review a public interest litigation that sought guidelines for the Braille integration system's implementation across all public and private sector domains. After issuing the notice, a bench led by Chief Justice D.Y. Chandrachud and also comprising of Justice J.B. Pardiwala and Justice Manoj Mishra sought comments from the central government and state governments within 4 weeks. The petition, filed through Advocate Nishant Kumar, specifically sought the implementation of the Braille integration system in currency notes, product labels, public spaces, and education at all levels. The PIL highlighted that the country is lagging behind other nations in providing visually impaired people adequate facilities to live life with dignity and equal opportunity, even though the advent of Braille and other supportive technologies have provided some succor against loss of vision. That was all on today's legal news. Thank you and keep watching Verdictum. Subscribe to our channel and download the Verdictum app on iOS and Android devices for latest legal updates.